I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the Black Robe.
All right, guys. Today we're dropped straight back into Judge Green's courtroom, where Frank opens with the exact same sovereign citizen circus that already failed before two other judges. No legal arguments, no facts, just rehearsed fantasy language meant to sound intelligent, but dodge responsibility. The moment he introduces himself as a beneficiary, you can feel where this is going. This isn't a defense, it's a stall tactic wrapped in pseudo-law, and the court knows it.
This is 210736FY. This is State of Michigan versus Frank Michaud. May I have your appearances, please?
Good afternoon, Your Honor. Mohammed Mohammed on behalf of the people, P86771.
Would you state your name for the record, sir?
My name is Frank Michaud. I am the beneficiary of the Frank Anthony Michaud estate that you are administrating over, and I appoint you as the trustee for the record. Let the record show. I am here as making a special appearance, not general. I am here on the duress and coercion.
Thank you, Mr. Michaud. Today is the day and time scheduled for the preliminary examination. In this matter, there is count 1, weapons, firearms, possession by felon. Count 2, carrying concealed weapon. Count 3, felony firearm. Are the people prepared to proceed?
We are, Your Honor. We do have a couple preliminary matters.
Before we do that, Mr. Michaud, are you prepared to proceed?
No, ma'am. I'm actually here to get a better understanding of things first before any proceedings.
What is it that you need to get a better understanding of, sir?
For one, is the jurisdiction that the court is operating upon.
Judge, I'm going to object. The court has made a decision on this motion previously. Both you and Judge Oakley have ruled on this, so I'm going to object.
Mr. Mohammed, hold on one second. Mr. Mohammed, what we will do is let Mr. Michaud make his record.
Yes, ma'am. Okay. Constitution, the Sixth Amendment grants me the right to know the nature and the cause of the action. I know the jurisdiction that you're operating upon for the record.
The next thing, sir. The next thing. You said you had some preliminary matters, which suggests more than one thing.
Oh, yes, the jurisdiction.
Buckle up, guys, because this is where the illusion starts cracking. Frank demands to know the court's jurisdiction, as if repeating it will magically change reality. The judge doesn't hesitate. She reminds him this is criminal court, not a role-playing session, and then drops the hammer by pointing out the real issue. He's a felon who brought a firearm to an airport. No theories, no codes, just facts. And facts don't negotiate with fantasy.
Yes.
What's next?
Is this going to be criminal, civil or criminal? And I also want to, with the basis of that answer, I would like to address some other things as well.
What other things, sir?
It's pertaining to off your answer. So.
Mr. Michaud, I think we had this conversation last week. Correct me if I'm wrong. This is a criminal case. It is alleged that on February 23rd, 2021, at the Detroit Metro Airport, which is located in the city of Romulus, you committed the following: that you did possess and or transport and or purchase a firearm when ineligible to do so because you've been convicted of violation of Controlled Substance Act 333.74012A4, a specified felony, and the requirements for regaining eligibility had not been met. Contrary to MCL 750.224F, count 2, carrying concealed weapon, that you did carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, to wit, a Range Rover. Contrary to MCL 750.224. Count 3, felony firearm, that you did carry or have in your possession a firearm, to wit, a pistol, at the time you committed or attempt to commit a felony, to wit, felon in possession of a firearm. Contrary to MCL 750.227B, there is also an habitual offender third offense notice on the file where it's alleged that you were convicted of the offense of violation of Controlled Substance Act on October 24, 2013, and convicted of the offense of attempt carrying of a concealed weapon on April 30th, 2002. That being the case, the court having responded to the charges indicated to you that this is a criminal matter, the court's question back to you, sir, is are you prepared to proceed with the exam in this matter?
No, no, you still haven't stated the jurisdiction of the court for the record.
All right, guys, this is where excuses run out. The judge gives Frank three choices: proceed, waive, or adjourn. Simple, clear, final. Instead of answering, he spirals into accusations of being threatened, even though the judge never mentions contempt. What's actually happening is control slipping away. He wants authority without accountability, power without consequence. And this is the moment courts are built for, when reality finally interrupts the performance.
That the jurisdiction of the court was Michigan statutes, and that's not what you're saying today.
Chief Judge Brian Oakley, you had a conversation with him about a month ago. We're having a conversation, well, we're having a hearing today. And sir, we're doing one of three things today. We are proceeding with the exam, you're waiving the exam, or we're adjourning this matter. Your response to my question right now is one of those three things. What are we doing this afternoon?
And you also stated that you addressed me having questions, and I had another question pertaining off your answer, and I wanted to read that.
Mr. Michaud, no, we're not doing this afternoon. Exam, waiver.
Well, at this moment, okay, since I'm under threat, arrest, and coercion, I would like to appoint Mr. Sullivan as trustee.
Buckle up, guys, because this part is the intellectual crash landing. Frank starts reading federal code like it's a magic spell, insisting all crimes are commercial and there must be an injured party. The judge dismantles it piece by piece, calmly exposing that the law he's quoting has nothing to do with his charges at all. This isn't civil. It's not corporate. It's criminal. And you can tell this is where the fantasy finally collapses.
Well, you say I'm not under threat, right? And if I continue to ask a question, I will be held in contempt, which is a threat, right?
I never said contempt, sir.
Well,
What we are is scheduled for a hearing, and what this court does is hearings. And I entertained some of your questions, but it is now 2:15.
we just.
And the courts, I know, sir, but I'm presuming that there will be some testimony.
Okay, but you're asking me, am I ready to proceed? And you, while you're asking me, you also telling me that we about to proceed, so you're not actually giving me the right to answer the question. You also making it seem like you're threatening me, so
Mr. Michaud, I'm interrupting you to tell you that I'm not threatening you,
okay,
but
so-
I've answered all that needs to be answered from this court to proceed with either the
well,
exam,
you
a
haven't-
waiver.
Okay, all right, but you haven't answered the questions that I have asked. I said I had another question, and you're still not allowing me to ask the question. So do I have the right to?
What's your question, Mr.
Okay,
Michaud?
I just want to ask you, far as. Hold on one second. I want to read this for you.
No, sir. You had a question. What is your
Okay,
question?
Can you help me understand this? Okay, according to 27 CFR 7211, it say all crimes are commercial and must have nature and cause and be prosecuted in the name of the people of the states as a real party and interest, not the people of the state, the corporation, the fiction. This is 20 FCFR, right? So I'll need you to elaborate on this code for me, please, and thank you.
Mr. Michaud, this court will decline to elaborate or respond to that because this afternoon we are here to determine if the prosecution is able to show that a crime has been committed and that probable cause exists to believe that you are in commission of that crime. That is what we're doing this afternoon.
I understand, but
Okay.
this says that possession of a deadly weapon is a commercial crime, so we have to I need to have a better understanding if this is a commercial crime. You said this is a crime, and there is no injured party where I hurt anyone. You haven't gave me the right to face my accuser, and it tells me under this code, 27 CFR 72.11, all crimes are commercial. A deadly weapon is considered a commercial crime. So I understand that commercial is civil, but you telling me this is criminal. So how is it criminal? And it says if there must be an injured party for a corpus delicti, for the record, an injured party, and you haven't presented an injured party for the record. So, I mean, can you elaborate on what jurisdiction you operating under? Is this
Mr. Michelle,
civil or criminal? Because it doesn't make sense to me.
You can say that again.
It doesn't make sense.
All right, guys, this is the moment that ends the game. After all the noise, legal jargon, and delayed tactics, the judge delivers one sentence that wipes everything out. The prosecution met its burden. Case bound over. Real court. Real charges. Real consequences. This is what sovereign citizen arguments never survive. Decision time. And with that, illusion meets authority, and authority doesn't blink. If you like this breakdown, make sure to like, subscribe, and we'll see you in the next video.